Welcome to this episode of Post Grant Radio, brought to you by Fish & Richardson. This podcast is dedicated to discussing the latest news and developments in post-grant proceedings before the Patent Trial and Appeal Board. Host Rick Bisenius, an attorney at the Twin Cities office, talks with practitioners and thought leaders across the country discussing a wide range of post-grant topics.
Hello, this is Rick Bisenius. Welcome back to another episode of the Fish & Richardson Post-Grant Radio Podcast. Thanks for joining us today. I'm really excited about the guests we have on the show today. We have Kevin McNish, managing member of McNish PLLC, and formerly a partner at Damaris. Welcome to the show, Kevin.
Thanks, Rick. Thanks for having me.
But before I have you fill us in on your background and your practice, I briefly just kind of want to talk about how you and I got acquainted, just because, most listeners are going to be aware of the traditional ways that you meet colleagues in the legal and patent fields, going to conferences, trade shows, maybe alumni events from law school or undergrad. But it's now 2022. We're entering our third calendar year of pandemic times in the United States, and we got acquainted in a very 2022 way, or pandemic times in the United States sort of way. Kevin and I met during an all-day virtual CLE event in a 3-minute networking session.
Very 3 minutes, extremely 3 minutes.
Yeah. One of the two of us, I remember being cut off in mid-sentence as we were talking about having you on the podcast. But fortunately, I was able to get your name before we were cut off at the end of the 3 minutes and get your contact info and email you. So I'm glad to have you on the show. And why don't you tell the listeners a little bit about your practice?
Sure, and thanks again for having me. So my practice focuses on patent trial and appeal board proceedings and related appeals to the Court of Appeals for the Federal Circuit. It focuses, I represent both petitioners and patent owners, a mix of each, so I'm not, fully committed to either side. Technology-wise, it pretty much runs the gamut. I do a lot of electrical stuff, a lot of mechanical stuff, med device, a little bit of life sciences. It covers a fairly broad practice. It's also a solo practice. It's just me and also my basset hounds, who are very important parts of the firm, despite being dogs.
Before we jump into, the subject matter, that you're on to talk about today, the appeals to the Federal Circuit, I want to talk a little bit about, how you ended up living in Maine. You kind of, looking at your LinkedIn profile, you kind of bounced around the country. You were in Tennessee, then Virginia, then California, then New York. How'd you end up settling in Maine?
I always say I took the long way, as you just alluded to. So I, grew up in Tennessee. First job out of law school was in California, then worked at New York at Damaris. After I left Damaris to launch my own firm, my wife and I took some time off. And as part of that time off, we went up to Freeport, Maine for a week. We've been to Maine several times on vacations. We had some friends get married here a few years ago, which is what started it. And, just really enjoyed our time in Maine every time we went up there. And so as we're driving back from that vacation, this is in late July 2020, we're stuck in, Queens Midtown Tunnel traffic on the Long Island Expressway trying to get back to our place in Long Island City. And, we just thought, why are we coming back to this? Like, why? We love Maine and New York we're kind of falling out of love with. As I started doing business development for my firm, still in New York at the time, I started to realize, hey, I can do this from everywhere, client bases from everywhere. I'm not really, pinned to any particular location. We both sat down and realized, hey, let's live where we really love living in Maine all the times we've been up here. And it made sense for starting a new firm too. Cost of doing business and living is so much lower up here. And, after my wife's job went permanently remote, shortly thereafter, that was it, so we moved up here in December 2020 and I've loved it ever since.
Yeah, I'm sure if your practice is anything like mine, you're dealing with clients not just all over the country, but all over the world. And so you really just need a phone number and an email address, and you can be located anywhere.
Yeah, exactly. And of course, the fun part of Maine is there's a lot of phone numbers still available. And so I had a really, it's funny in New York, you like fight for phone numbers that have lots of zeros in them. In Maine, I got a one with lots of zeros in it very, very easily. I really love living up here. Really enjoyed just meeting folks both inside and outside the legal community. It's been a great place to live and work.
I have to say, as somebody that grew up in Wisconsin and currently lives in Minnesota, I really respect people that grew up in the South and are willing to move north to the colder climate. So my hat off to you.
Well, thank you.
All right. So, yeah, I brought you on the show to talk about, specifically appeals to the federal circuit from the PTAB. And to start off, if you're going from the PTAB, where there's really two positions, you've got petitioner and patent owner, going up to the federal circuit, that kind of turns into four positions. You either have a petitioner that won below, or a petitioner that lost below, or patent owner that won below, or patent owner that lost below. Or sometimes, there's a mix of both. There might be some claims were found valid, some claims were found invalid. So there's a lot of different positions going on. So starting off with, patent owner, what are some tips that you have on what you can do to after institution to improve your likelihood of success at appeal if you're not successful at the final written decision?
Mm-hmm. Sure. So, as a patent owner, if trial's been instituted, you've all seen the statistics. It's your odds of getting at least one claim canceled are very high, and your odds of a complete wipeout are, also very high. So, as a patent owner, you need to position yourself to have an effective appeal at the federal circuit, and that starts with knowing your standards of review. Understand that factual issues are typically reviewed for substantial evidence. Claim construction issues and other legal issues are reviewed de novo. So you need to understand, given the likelihood that, unfortunately, you may not prevail at the PTAB, find yourself issues that are going to be reviewed less deferentially at the federal circuit. And to the extent you've got anything reviewed for substantial evidence, know how you can beat issues reviewed for substantial evidence or flip those issues. For substantial evidence, two of the things you can do. One is identify arguments where there's legally insufficient evidence. Oftentimes that comes in the motivation to combine context, where there's a legally insufficient rationale to combine references. The other is to identify areas where the petitioner's contentions are clearly against the written record. In other words, what a reference says or what a person of ordinary skill in the art would understand. Something where there's a clear contradiction there, because both of those areas can get you, a reversal or vacate and remand even under the substantial evidence standard. So target those issues and then tee up anything you can review de novo as best you can, especially claim construction.
Seems like a lot of those tips would apply equally on the petitioner side as well. If you're on the losing side as a petitioner, identify issues you can get reviewed de novo, like claim construction. Maybe identify, issues on motivation to combine. Any tips that you have that are specific to the petitioner side?
Yeah, so petitioner side, you need to use your reply brief very effectively, and your reply brief at the PTAB, because a sophisticated patent owner is going to do everything I just said. So what you want to do is start reframing purportedly legal issues as factual issues. If you have some kind of claim construction argument being presented against you, show that your references meet the claim construction, even as proposed by the patent owner. And, consider introducing, if to the extent you haven't already, extrinsic evidence and expert testimony to support, your own preferred claim construction. Remember, trial's been instituted. More likely than not, you're going to prevail in the final written decision. So if you can get these sorts of factual issues in that are going to be reviewed for substantial evidence and can shore those things up, that can often put you in a stronger position to defend a decision on appeal.
That's great advice. So that's what you can do in the briefs down below. Is there any specific advice you have for an oral argument? What you should be doing at the oral argument to put your position in the best light for likely appeal?
Sure. So my number one tip is be smart about what you're willing to concede at oral argument and how you concede it. Both the PTAB and the Federal Circuit will often try to extract concessions from the parties at oral argument to narrow the issues, and that's normal. That's a typical part of oral argument. But if you concede a point, you might end up waiving your ability to argue that point on appeal. So, for instance, if you're presented with a hypothetical that assumes you've conceded something, you might answer with, well, we don't concede that's the case, but even if it were, we still win on this issue because X, Y, and Z reasons. And that brings me to another point. Make sure you're mooting your PTAB argument in front of folks who know your case well enough to try to present those concessions to you. And that way, you can make those concessions intelligently and you're not doing them on the fly for the first time.
Yeah, it makes sense. Know your case well, and and make sure you're doing what every good lawyer should do in any oral situation, hedging everything that you say.
Mm-hmm.
All right, so let's say you've gotten you're done with the oral hearing, you've gotten the final written decision, things didn't go your way. What factors do you weigh when you're considering whether to appeal a case versus request a rehearing at the PTAB versus just kind of taking your loss?
Sure. So, more often than not, when I'm looking at a case where the final written decision hasn't gone our way, my typical recommendation is to go straight to appeal. And the reason for that is if you file a request for rehearing, it'll just encourage the board to fix any issues that might be in its final written decision, and that can end up shoring up its final written decision for appellate review and making your job harder on appeal. Even going for director review after Arthrex may not necessarily be worth it, both for how infrequently it's granted and how infrequently it actually makes a difference. That said, if there's some kind of tight, discrete issue, like maybe something that doesn't affect other things, you might consider what I call clearing the deck with a rehearing request just to knock out, that sort of tight, discrete issue. Maybe it's a dependent claim. Maybe it's something where it's something you wouldn't necessarily have space to argue on appeal, or it's something that's not going to cross-cut across the entire decision. That might be worth pursuing, but my threshold even for that approach is a pretty high one, and my general rule is the error has to be so clear that even my opponent would think, well, the board may have done something wrong here. So it's something that I don't typically use. I know there are folks that try to use it to create delay at the PTAB so that maybe something happens in the district court that's favorable. The PTAB knows what you're doing. The Federal Circuit knows what you're doing too in that scenario. So really be judicious in how you use requests for rehearing.
You've kind of touched on my next question already, but I'll ask it anyway because you can give it in this context. But once you've decided to file an appeal, how do you select what issues you're going to raise in the appeal?
So more often than not, I'm looking for de novo review issues. So if I'm the one that's written the patent owner response, or if I've worked with the crafting the patent owner response, typically that means I've got some legal errors teed up and I've got some claim construction issues teed up. And I like both of those as an appellant because those are both reviewed de novo. If I have to litigate a substantial evidence issue, and it does happen, anticipation is reviewed for substantial evidence, so is motivation to combine. I look for sort of the two sorts of issues we touched on earlier, which is either some kind of no evidence or legally insufficient evidence scenario, or a clearly inconsistent with the record decision. Something where maybe somebody's expert said the opposite of what the prior art reference actually says. And target that. All of this ties into the notion you really got to know your standards of review and how they operate.
Okay, so when you're evaluating all these issues that could potentially be involved in the appeal, how many issues do you usually, would you recommend that somebody raise in their appeal?
So my general rule is as few as you need to win, and preferably no more than 3 per final written decision you're appealing. And when I say 3 issues, I mean 3 issues, not 3 with a whole bunch of subparts that, if you were in district court, you'd say, oh, this is like 15 interrogatories instead of 3. And ideally, all 3 of those issues tie into some kind of overarching thematic error, some kind of deeper fundamental error the board committed. Maybe they didn't understand the technology. Maybe they didn't consider the claims from a person of ordinary skill. And what you're really looking for is sort of one overarching theme, and then up to 3 errors that ideally tie into that theme.
So you mentioned, maybe one of the errors would be because the PTAB judges didn't understand the technology. I'm kind of curious. Do you feel that in situations like that, you'll have a better chance of getting the Federal Circuit judges to understand the technology?
Often, yes. And you saw a little bit more of this in the context where we were moving from broadest reasonable interpretation, or rather the PTAB was using broadest reasonable interpretation, where sometimes you would get a misunderstanding of the technology, which would then lead to an overbroad claim construction of the district court. At the PTAB in the final written decision. One appeal I had where this happened was, both experts had said, hey, this is a very narrow problem in a very narrow environment that, the patent addresses. And, our expert had contended the prior art didn't teach this particular environment in which the invention operated. And, the PTAB ultimately broadened out the claims to say, well, the environment you're alleging is required isn't actually required under BRI. And so at that point, we had to bring in not only what our experts said, but what the other experts said, the opposing experts said, and said, hey, PTAB kind of got the technology wrong here. This is a very narrow solution for a very specific use case, and the prior art just doesn't teach this use case. And that ultimately led to a vacate and remand, case settled afterward. But, that's the kind of scenario where, the board's going against both experts, and that can kind of suggest maybe the technology did not get understood well, and you can often use evidence that you've presented at the PTAB and package that, keep the same arguments, but package it a little better for the Federal Circuit.
Oh, that's great. So basically, you really have to do your due diligence on the facts of that specific case and really assess, is there a hook here that I can explain what the error was below?
Mm-hmm. And, you can use your statement of the case in your brief to do that. One of the things you have to include in your Federal Circuit brief is a statement of the case, covers the relevant facts of the case. And oftentimes that's a really great opportunity to give a, tech tutorial to the Federal Circuit judges, and especially if you have some favorable expert testimony from the other side's expert, you can incorporate that in as well. So, what you're presenting is saying, hey, everybody agrees that this is the what's going on in the technology, and here's, kind of the error that the board made given that it misapprehended the technology.
Great. So I'm wondering if you have any thoughts on arguing issues that aren't related to the specific case, more procedural issues. The American Invents Act, even though it's almost a decade old at this point, still a relatively new law and still a lot of things being figured out by the courts. And so we've seen a number of challenges under the Administrative Procedure Act and constitutional challenges to PTAB trials. I'm wondering if you have any thoughts on how to deal with those issues in an appeal.
Yeah, so I'll start with the Administrative Procedure Act issues. One of the things that appellants should understand is just any procedural flaw isn't necessarily going to be enough to overturn the outcome of an unfavorable decision. If a successful Administrative Procedure Act argument, you really need to show two things. You need to show, one, that this decision, the board's decision, had some kind of procedural defect. It was arbitrary, it was capricious. There's some kind of internal inconsistency. Not all of the evidence was considered. You were deprived of due process. So that's the error you have to show. But then you also have to show the prejudice from the error. In other words, is there a substantial likelihood the outcome would have been different but for the procedural flaw? A lot of appellants sometimes, and earlier in my career, I was occasionally guilty of this as well, would really just say, oh, the prejudice is self-evident. Oftentimes it is, but you really need to tee up for the board how things would have gone differently, but for the procedural defect that you're appealing or that you're alleging in your appeal. So turning to constitutional issues, one thing an appellant raising constitutional issues should know, and this is something the Federal Circuit's really put an emphasis on with a sort of flurry of post-oil states constitutional litigation, get your Federal Rule of Appellate Procedure 44A letter in ASAP. So what that is that's a letter required under the Rules of Appellate Procedure in which you flag for the court that you're raising some kind of constitutional challenge to the statute. That needs to go in as soon as you think you're going to raise the constitutional issue, earlier than your opening brief, usually ideally with your docketing statement, and that comes up 14 days after you file the appeal. So if you're going to do that, do it quickly. The other thing, if you're litigating constitutional issues, there have been a lot of adverse decisions to constitutional challenges made by patent owners. If you are preserving something for either en banc review, challenging precedent of the Federal Circuit, or Supreme Court review, you still need to acknowledge that authority, distinguish it as best you can, explain why it's wrongly decided as best you can, and then, candidly acknowledge, we understand, Federal Circuit panel, that you can't overturn other precedential decisions of the Federal Circuit. We're doing this, preserve this for en banc or Supreme Court review, but, we are aware of this contrary authority. We respectfully disagree with it. And, we've preserved our ability to further challenge it by fulsomely making the arguments in our briefing.
So, in the last few years, how often are you advising clients to include these kind of constitutional challenges in their appeals?
So back before, right after oil states and around oil states, I actually was a pretty aggressive constitutional litigant, particularly on the retroactivity provisions of the American Invents Act, how it applied to subjected pre-AIA issued patents to the IPR regime. These days, a lot of those decisions have been made. A lot of it has become a lot more settled than it was, 5 years ago, even 2 years ago, especially with the Celgene Federal Circuit decision finding no takings worked by the retroactive application of the American Invents Act. So, my advice these days would be, have a new angle. That's something I would definitely recommend is, know what's out there, know what's been litigated, understand that, if you're a patent owner raising these constitutional challenges, a lot of them have been decided. So, understand the universe of precedent you're dealing with, try to come up with a new angle if you can. But if you're trying to preserve something for Supreme Court review, be as respectful as you can about it, preserve as much as you can, present your argument fulsomely, and, understand that your best chance is the Supreme Court granting cert, which even then, it's an uphill battle.
Yeah, that's an understatement. Are there any issues that you would generally advise against including in your appeal from the PTAB?
Yeah, so, straight substantial evidence issues can be challenging. And, I would really think twice about litigating a substantial evidence issue where I don't have some kind of no evidence angle, some kind of legally insufficient evidence angle, or some kind of clearly clearly inconsistent with the record angle. Oftentimes that's a quick trip to Rule 36, affirmance without opinion. If you're a petitioner appealing, don't raise constitutional challenges to the Patent Trial and Appeal Board. A few have, and the Federal Circuit has said, well, you sought adjudication, and now you're complaining of a constitutional issue with that litigation that you yourself sought out. Mm-hmm. So that usually just by invoking the PTAB's jurisdiction, you're going to, as a petitioner, you're going to find a tough audience for any constitutional arguments. And then, constitutional issues as a patent owner, as we, just discussed, if you've got a new angle, by all means, go for it. But, understand that a lot of this has been litigated and most of it has been decided in a way that's not necessarily friendly to the constitutional challenges.
Okay, so let's say that you did win down below and now you're facing an appeal. What situations would you recommend that a party file a cross appeal?
So save your cross appeals for trying to change the outcome, the overall outcome on a claim. If you're looking to file a cross appeal, you need to be enlarging the PTAB's judgment in some way. So if you're a petitioner, that means you're looking to take out a claim that the final written decision upheld, and vice versa. If you're a patent owner, you need to find a claim that the patent office held unpatentable to, cross appeal that. If you're looking for alternate reasons to affirm the board's decision, you can raise those in your responsive brief. Understand you do have some limits on that, though, actually, under what's called Chattery Doctrine, which is a doctrine that at a high level prevents the Federal Circuit from affirming a board decision in a way that would require the court to find facts where the fact finding is committed to the Patent Trial and Appeal Board. So, if you are a appellee at that position, you can argue your alternate basis for affirmance and then say, well, to the extent this requires any additional fact finding, vacate the decision, remand to the Patent Trial Appeal Board, let them find those facts so we can get this decision in our favor.
Yeah, that makes sense. I've definitely been in situations where we're representing the winning party on the appeal, and for additional reasons for affirmance, we've argued, hey, the board got this claim construction wrong, and so here's what we think what the correct claim construction should be, and this is an additional reason that you should affirm. Mm-hmm. Okay, so we've talked about the issues that you would raise in your appeal. Let's talk about any practice tips you have for the briefs. Any advice for practitioners when they're drafting their principal briefs?
So one thing I like to do, we talked about theme already, and one thing I like to do at the beginning of my briefs is include an introduction. It's not a required component. It's not in the Federal Circuit rules. But I like to use my first, maybe 2-3 pages or so to really set the theme. And, as the appellant, that's the overarching error I've identified that then leads to my up to three issues I presented on appeal. Now, if I'm the appellee, I also would include an introduction, but at that point, you need to select your theme not based on the board's final written decision, but on the appellant's brief. And so, that's where you really need to take a look at errors in the appellant's brief. For instance, maybe the appellant gets a legal principle wrong, and then, you focus on that. Maybe the appellant's trying to frame all of these legal issues purportedly reviewed de novo maybe the appellant's trying to frame these issues as these legal issues for de novo review, when in fact they're clearly factual issues for substantial evidence review. And you can always emphasize how thorough the Patent Trial and Appeal Board's final written decision was as the appellee. As the appellee, use the appellant's brief to actually frame your theme, frame your introduction. And the other tip for both sides is use your standards of review. Like, understand what substantial evidence means, understand how the court has applied it. And in your standards of review section, both appellee and appellant, make sure you've got some favorable formulation of that standard of review, and then work that into your brief. Show that, your case, this appeal, fits into, you've climbed the mountain of substantial evidence review as the appellant, or, the Patent Trial and Appeal Board did something reasonable as the appellee, and reasonable, even if potentially erroneous, is still going to get affirmed on substantial evidence review just because it's a deferential standard.
So when you're making that sort of argument, are you focusing more on the way the case law has defined the standard, or more on your specific facts, or is it really a comparison between the two?
It's both. So, substantial evidence, I'll give an example. So for anticipation, substantial evidence, one of the ways that you can overcome that is to show there's actually an erroneous claim construction, and the board has stated the Federal Circuit has stated if there's not substantial evidence, we won't hesitate to, overturn this particular case. Then, I'll get into, what evidence was actually at issue in the Federal Circuit, overturning a decision made on an issue reviewed for substantial evidence, and say, hey, by the way, our case looks a lot like this one. In this previous decision, a PTAB decision was overturned because there was no evidence on a particular claim limitation, or no evidence of motivation to combine. And guess what? Our case is just like that too.
Any advice on what to focus on when you're preparing your reply briefs?
So address all of the arguments in the red brief, the appellee's principal brief. Don't drop anything unless you are 100% sure you're just willing to let that go completely uncontested. And it is a rare issue where that comes up. The other is, just remind the Federal Circuit that to the extent the appellee is raising alternative basis for affirmance, they can't find new facts in the process of affirming. And so if the appellee is urging alternate bases of affirmance that require additional fact finding, that's not a basis to affirm, that's a basis to vacate and remand. And then, that gets you back at the PTAB where, you get to litigate your factual record anew.
I'm wondering if you think there's anything special that parties should be focusing on when they're preparing a joint appendix.
Sure. So the deadline comes pretty quickly. It's 14 days after the certified list is served. But that said, most PTAB appellate litigants will designate the entire record of the proceeding, papers, exhibits, everything, as the initial designation. So it actually makes things a lot easier. And if things drop out along the way, that's fine. The Federal Circuit has long permitted parties to use non-consecutive pagination in the final appendix, although the initial appendix does have to have consecutive. So there's a specific order you need to follow. First item is always the final written decision. Second item is the certified list, and then remaining items, papers in order, and then the exhibits in order. And one really neat trick is that if you're in PTAB E2E, you can actually export to Microsoft Excel the lists of papers and exhibits, including the number of pages each item takes up. And once you've got that, you can kick that out to Excel, and with a little bit of Excel trickeration, you can assign page numbers very, very quickly and have an entire appendix very, very quickly.
This is some excellent IT advice that we're getting as well. Okay, so we've talked about the briefs, we talked about the issues. Let's talk about the oral argument. And I've always found this to be really interesting because I've always thought of, what are referred to as PTAB trials. I've always thought of those oral hearings as being more similar to an appeal hearing than to, a district court trial. So I'm wondering if you can tell me a little bit about how you prepare for the oral hearing and maybe what are some differences between how you think about the Federal Circuit oral hearing versus the PTAB oral hearing.
Sure. So, one big difference in how I prepare for PTAB hearings and Federal Circuit hearings is that if I'm at the PTAB, I generally want to make sure I use all of my time. That's not necessarily true at the Federal Circuit, where if you get through the issues you've presented, you haven't waived anything by, failing to present an oral argument because you've briefed it. And in some instances, if I've gotten through my points and it looks like I've got my points across, I'm willing to, sit down. By contrast, at the PTAB, usually I have enough material to use all, the full hour I've been allotted. And oftentimes it's good advice to use all of that because you're going to need to get into much greater technical detail. You're going to get more questions on more issues. And oftentimes you have more issues that you're actually litigating at the PTAB than at the Federal Circuit. At the PTAB, you may have all kinds of issues. You may have argued tons of dependent claims separately. If you're the patent owner, if you're the petitioner, you may have multiple different grounds of unpatentability you've presented and you want to hit all of them. There's usually almost always enough to occupy the full hour. But, at the Federal Circuit, things are so tight that oftentimes you've got, you made your points and you've answered the judge's questions. You may not necessarily need to continue, especially if you're the appellee. You might be done in 5 minutes and, that's the end of it. But otherwise, I'll tell you my process for preparing is actually pretty similar. Typically what I have is 2 sets of notes. One set of notes is what I call my marks, and that's just a single sheet of paper that has every mark I want to hit. So it's got, usually like a quick 30 to 60 second introduction that I actually do usually write out in full, and then like a 1 sentence for each issue that is my theme for the issue or is my overall distillation of that topic and how I want to argue that issue. Then for each sentence, each topic sentence, each mark I have in that 1 sheet, I have a separate sheet of paper that covers all of my citations for my, that particular mark that I want to hit, and I call that my module. Oftentimes that'll also include anticipated questions and how I would propose answering that questions, and then anticipated counter arguments from the other side and, how I'd address those as well. So I typically have, at my left side at the podium, I've got just 1 sheet, single-sided, and on my right side, I've got, depending on how many marks I've got, like 1 page per mark. So a couple pages of notes, 4 or 5 pages of notes is pretty typical for me.
Seems like a pretty efficient system. Those podiums are pretty small at the Federal Circuit.
That's part of it. And the other part is I found earlier in my career when I was doing the oral arguments, whether at the PTAB or at the Federal Circuit, one of the most difficult things for me, and I think it's true of a lot of advocates, was to learn how to transition between answering questions, playing defense, and then affirmatively presenting your case, presenting your arguments, playing offense. So having all of my marks, handy and, each topic I want to hit right in front of me helped me really pivot back and forth from playing offense and defense effectively. And it helped me minimize any dead air during my oral argument presentations.
Great. So you mentioned you've got this list of marks, the issues you need to hit when you're up at the podium, or at least the issues you want to hit while you're up at the podium. Mm-hmm. In preparing for the oral argument, are you scripting out those arguments ahead of time and rehearsing your scripted lines, or are you really just making sure that you're familiar with each argument so you can respond to the questions coming from the bench?
So I typically only script maybe the first 30 seconds, and that scripting is actually a very living process, especially going through moots. The other very, very critical part of preparing for oral argument. That's a way to collect feedback during that process. But for the most part, my marks and modules are designed so that I can improvise on the fly. That's why often it's very nonlinear. You don't get to present issues in the order that you necessarily want to present them, and you need to be prepared to jump around. My marks and modules process really facilitates that, because if I get questions on another topic, I say, okay, I know that's mark 2. Let me just flip to page 2 of my notes, and I've got that right in front of me. And even then, like if you look at my like one of my modules pages, for instance, it looks like almost like the diner menu, like when you see an NFL coach calling plays and they've got their play sheet up next to their face. It's literally 2 columns, like 10-point font. Just really tight, distilled bullet points. I can work with those to present an oral presentation, as opposed to just, reading out, notes for 15 minutes. Federal Circuit doesn't want you doing that. PTAB doesn't want you doing that. So, ultimately, they want to ask you questions, and you want to be able to answer those questions without coming across as too robotic. And, having those kind of bullet points helps you develop that fluency.
Thanks, Kevin. I appreciate that. I think that's all the questions I had. I really appreciate you walking through this whole topic. And, for someone like myself, I haven't actually conducted an oral hearing at the Federal Circuit. I've accompanied others that have done it, but getting your perspective on it is really interesting. So I warned you about this next segment, but as I've mentioned, I always end the show with what I like to call the lightning round. And so we kind of discussed some of the topics we'd already talked about ahead of time, but these, you have not seen these before. Are you ready?
I'm ready. Let me get my marks and modules out for this.
So you can pass on any of these. There aren't any. Well, some of them actually do have correct answers, but for the most part, there aren't really correct answers. But all right, question 1. So I mentioned you mentioned that you grew up in Tennessee, and you went to Vanderbilt. What's the best honky tonk in Nashville?
Oh, so with the caveat that I did not spend a lot of time in honky tonks in Nashville, I was a bad Nashvilleian in that respect. Lonnie's was a very popular haunt for Vanderbilt students. I heard it had a great karaoke night.
Awesome. I'll make sure to check out their karaoke next time down there. All right. Question 2. Which Supreme Court decision sparks more joy in you? SAS Institute or Arthrix?
So I'm actually going to say SAS, and it's a bit of a hot take in the patent owner community, but I think it's a much more patent owner friendly decision than a lot of people realized at first.
All right, I got a softball question for you here. How many days does a party have to file a notice of appeal to the Federal Circuit after the final written decision?
I just had a question on this yesterday. 63, and then you've got 14 days after if you're filing a cross appeal.
See, that's bonus points for the cross appeal days. So you've already got 4 points and only 3 questions in. All right. Okay, so I actually asked this question to a recent guest because he was from Boston, but I couldn't help asking it of you also because you live in Maine. Where's the best place to get a lobster roll?
Red's Eats in Wiscasset, but if you don't want to deal with the lines there, and the lines there can be considerable, High Roller Lobster in Portland is also an excellent place to get a lobster roll.
This is great advice. All right, we got 2 more left. This one might be a little unfair because we've been doing remote hearings at the PTAB for a while, and we were just talking about appeals, but this is a PTAB question. All right, you're at the USPTO office in Alexandria. You're heading to your PTAB oral hearing. You're past security. What floor are you headed to in the elevator?
I think it's the 6th floor.
Sorry, it's the 9th floor.
9th. It was one of those.
It's unfair. We've been doing these via computer for 2 years now. So.
Yeah, well, I'll have to tell you, a lot of my arguments recently have been in regional offices. So Detroit, Denver. It's been a while since Alexandria, though. Okay.
All right. Last question. This is a 112.6 or 112F under the AAA claim construction question. A claim element reads, a means for winning Kevin McNish's heart. What's the corresponding structure?
Ooh, I was going to say, the Lobster rules you mentioned earlier are a good start. Let's see. Yeah, you've got some equivalents there too. I also like a good BLT now and then. But who really won my heart are definitely our Basset Hounds at home here. They're great. They're wonderful, and they're an integral part of the practice. It was a running joke for a while that because I got a lot of my best ideas from Brees while out walking our older Basset, Norman, that he should be getting co-author credit.
See, that's great because that opens up a lot of issues for fact issues, like is a Corgi a structural equivalent to a Basset Hound? Like, I don't know. Maybe. All right. Well, thanks for coming on the show, Kevin. We really appreciate having you. Once again, this is Rick Bisenius, and thanks for tuning in to the Fish and Richardson Post-Grant Radio Podcast. Thanks, Kevin.
Thank you.
We want to remind our listeners that the content of this podcast is for educational purposes only and does not necessarily reflect the opinions of Fish and Richardson nor any third party involved, and is not intended to address every court or case situation. Be sure to visit fr.com to listen to all of our past episodes and subscribe to this podcast. You can also follow us on social at Fish Richardson.